Well, I think we've all been dealing with these pain points for many more months than we ever expected, reaching a peak in the last 3 to 4 months. And I think our topic's pretty timely. We know that everyone is dealing with this, so we hope that we have some valuable insights to share with you today. And it's not all bad news, and that we're looking forward to a different, brighter horizon. I'm Vanessa Miller, and I'm with my colleague, Nick Ellis. We are both based out of Foley and Lardner's Detroit office. By virtue of being in Detroit, both Nick and I do a lot of automotive and manufacturing supply chain litigation, as well as lessons learned, having seen these litigations play out over the years, commercial counseling. A big part of our practice lately has been talking with a number of you and others about, what can we do with respect to shortages? What can we do with respect to disruptions and pricing increase requests, and looking at it from both angles? So we're hopeful that today we'll be able to give you some tools and some guidance on trends that we're seeing play out. Here's the very, very it's quite the agenda that we're going to try and get through today. So we're going to be moving pretty quickly, and I want to make sure that we leave time for some of the case law trends and then a real high-level discussion of lessons learned, because I think that's this group probably has a pretty good understanding of some of the legal points. But before I get into the key defenses to performance under contracts, I think it is important to talk about the background. How did we get here? And I want to just take one example of something that many companies have been dealing with. We've been hearing about it from a global standpoint, and that is the microchip semiconductor shortage and how that occurred, because it really shows the perfect storm of how these things can arise and then snowball. We had the 2020 to 2021 COVID ripple effect that we're going to see play out. And there was a series of events that occurred to cause the microchip shortage. First, the OEMs, the vehicle manufacturers, drastically slashed their orders. Tier 1 suppliers then in turn decreased their orders. Now, they had orders into these chip conductors, of which TSMC, Taiwan Semiconductor Manufacturing, was the world's largest chip maker. 54% of all chips across the entire globe came from TSMC. Many automotive sourced solely from TSMC. And despite that being the major manufacturer of chips, what we saw is that there was only a small sliver of those chips at TSMC that were supplied to the automotive industry, 2 to 3%. So that's a really small sector and not a lot of bargaining power for automotive. Meanwhile, we're in the pandemic. Everyone's buying more laptops, more iPads. Kids are schooling from home. Adults are working from home. And the new capacity that TSMC had from that 2 to 3% of automotive and other chip manufacturers had, that gets filled quite quickly by electronics companies, and they place their orders, and now TSMC and other chip manufacturers are at max capacity, even beyond max capacity, strained. Fast forward to Q3 through Q4 of last year, we see vehicle manufacturing increase, the demand increase. No one thought this would happen. Everyone got their stimulus checks and went car shopping. So all of a sudden, the OEMs increased their orders, which has the domino effect of the tier 1s needing more components, including microchips. Find out that those orders are 6+ months out as of September of last year. There's no way to fill those orders. Going out into any order placed at the end of last year, November, won't even be delivered until September of this year. Major problem. Q1 2021, everyone thinks it's going to be much better when the new year was rung in, and then it's everything just got worse, particularly in the supply chain. Car plants shutting down across the globe. Ford F-150 shut down. No one would ever think this would happen. Combine that with just regular, ordinary course force majeure events. Earthquakes hitting Renesas, which is the major chip manufacturer in Japan, the unprecedented Texas storms, which swept across Texas, a drought in Taiwan that threatened even TSMC's continuity of supply, then a plant fire in Renesas. So the hits just kept coming, the Suez Canal blockage, and it further delayed the supply of semiconductors. Looking to now and going forward, where we are now, we're really at the peak of the semiconductor shortage, but it's going to continue into next year, and that's what all predictions are showing. We saw what we've been referring to as the toilet paper phenomenon. There may be the right amount of semiconductors out there, but what happened is, and we'll talk about this very quickly in a few minutes, but due to the requirement that suppliers reasonably allocate available supply, what the OEMs did was they said, they have to apportion out what they have available. So we'll just increase what we need. We'll just up our releases to like 200% of what we actually need, or 300%. And then that way, even if they allocate us just 1/3 of what they have, we'll get close to our requirements that we need. Well, that just created more confusion, just like the toilet paper hoarding did in the beginning of the pandemic. So I want to just talk quickly about some other areas. Every single one of these pinches that we're feeling, they're not all caused by the same issues. There's differences, and that's why it's important to understand these differences, because it just shows you how difficult it is to really mitigate risk. But we're going to talk about ways that you can do that, even since we can't predict what the next shortage or pinch point, pressure point is going to be. Lumber. Anyone that's been to Home Depot for a home improvement project or talked to a contractor knows lumber prices are way up. That includes packaging, and that's really impacting the shipment of components across many industries. Metals, precious metal shortages. Looking long term, there's a lot of concern as to whether certain metals are going to be available. Major concern for the upcoming EV push and batteries, for example, with respect to lithium, nickel, copper, cobalt. They're less readily available, mostly located in other countries, and mining for these metals is a major project that takes 10+ years. Steel doubled in price since 2 years ago. Resins, we're looking at an unprecedented increase in the price of resins, 21 to 35% over what used to be a fairly steady fluctuation point for resins, not something that companies were terribly concerned about fluctuating prices in. I think we've all heard about the chicken wing shortage over the summer, and now there's a major concern that people aren't going to have turkeys for Thanksgiving. I think the UK particularly is stressed on that front. There is the supply chain just can't keep the poultry in stock. Chlorine, and this is an interesting one that I just want to quickly touch on. Over the summer, there was a major chlorine shortage, and the reason had nothing to do with the other supply chain pressures that I've just highlighted. It actually had to do with a single plant fire in the US at one of the largest suppliers based in Louisiana of US-based chlorine. And plant fires happen, unfortunately, quite frequently. So you can't predict when or where the next plant fire is going to impact. Gasoline. Now there's been a bit of a shortage as we're in Q4. But in Q3, it wasn't a shortage of gasoline. It was a shortage of the drivers. You need a special license to drive a gasoline tank, and a number of the drivers had retired over COVID, and there's always been a threatened shortage of available drivers. And we're seeing that now across many different supply chains, that truck drivers are at a shortage. And then the holidays. Is it an increased demand? Is it people trying to get their gifts earlier, combined with shipping issues, port delays, labor issues, etc.? But there's a big concern about the holiday decor and gift supply chain for the upcoming holiday months. And then sometimes we'll hear, well, I'm not a manufacturer, so I don't have supply chain issues. But I think we can all agree that anyone on this call probably is interested in this, but it's hitting everyone. It's hitting regular consumers. It's hitting every company. Every company has a supply chain or is impacted by. Just recently, the Massachusetts state lottery didn't have the cards to fill out. So anyone that gambled in that round had a better chance of winning because they ran out of cards for the Massachusetts residents to fill in. All right, so not to be the bearer of bad news, but as many of you know and have already predicted, it's going to get a little worse before it gets better. COVID-19 was a great stress test. It was a perfect storm. But with the globalization of supply chains, with the electrification of everything, think about the increase in technology that we've seen. Everyone used to have one device, like a little flip phone, cell phone, and now we all have 6 or 7 electronic devices that we deal with and have with us regularly. In the manufacturing context, we're talking about what has traditionally been a just-in-time, lean manufacturing, sole sourcing model, extremely efficient when it works well, very saves a lot of cost, allows you to source high volumes from one supplier, get the best price from that supplier, not have to hold on to a whole bunch of inventory and waste storage costs, worry about product going bad, and it all runs smoothly until it doesn't. And that's what we've really seen in the last 18 months. We are dealing with unprecedented labor shortages and increasing wages that are straining companies more than ever before. The port delay situation is a continued problem, and it's causing further backups. And then the massive freight increases. So that's just with respect to the disruptions. And of course, that's going to drive price increases as well. But now there's this flurry, a blizzard really, of back and forth demands for price increases, stop shipment threats, and then refusals to pay for price increases, even though these price increases go to things like raw materials, freight, labor, things that are normally part of a company's cost walk when they quote their price. So what can we do? What are we trying to do? I think that the outlook going forward is really, this should be an opportunity for companies to re-examine their commercial contracts. That's where you're going to ultimately shift risk. A lot of these things right now are playing out at the negotiation table between procurement and sales groups. Maybe they're not playing out at all. There's a lot of litigation flying around, which we'll talk about as well. But there should be, going forward, when we can get back to the negotiation table on certain contracts, an increased focus on companies' supply chains, their planning, supply chain mapping, where everything is coming from, not just one level down, but below that. Because what we're hearing a lot of is sometimes a raw material might be sourced, or excuse me, a component might be sourced from a sub-supplier, but both those sub-suppliers source from the same raw material provider. So if there's an issue with that raw material, that's going to affect both of your suppliers, even if you have dual sourcing. Having contingency plans, I think everyone learned that. And then never wasting a good crisis. Let's look at what we can learn from this. And I think that at the end, we're going to talk a little bit more about shifting risk by re-examining contracts and making changes going forward. All right, so these are things that I know many are familiar with on this call. I'm going to walk through fairly quickly, but these are the 3 key defenses to performance under a contract. Force majeure, we're all sick of hearing about that, commercial impracticability, and frustration of purpose. So these theories are not the norm, right? Like the norm is that you perform under the contract and that you must perform as specified in the contract. These are defenses or excuses to performance under a contract that ought to be used sparingly. And then I'll talk more about that in a moment. But force majeure, this is a creature of contract. This is the provision that every single company turned to their terms and conditions and contracts at the beginning of COVID when the executive orders were getting issued and lines were getting shut down, and said, what is force majeure? Do I have this right in my contract? And then the letters and notices started flying back and forth. But this is a creature of contract. The contract will talk about certain events, usually weather related. Now we're seeing things like pandemic, epidemic included in this term that outright excuse performance while the event is occurring. I call it a contract timeout because it really says we're just going to take a timeout until this stops and we can start supplying again. It is not a breach. You are not supposed to be liable for damages during the duration of the force majeure event. Now, commercial impracticability. This is sometimes considered a backstop if force majeure is not available because it's not in the contract. This arises under the Uniform Commercial Code, Section 2-615, and it is available in all circumstances with respect to the supply of goods. Now, this is a situation where it's not an event that's outright prevented performance, such as like a force majeure event. Instead, it's that the performance of the contract has been rendered commercially impracticable by the occurrence of a contingency, the non-occurrence of which was the basic assumption on which the contract was made. What does that all mean? It means that something has happened that no one thought was going to happen when we entered into the contracts. This is really the proper door or avenue for a lot of the price increase requests and denials that we're seeing. This is where the parties should really be talking. But I would offer this group that I think that this is a very misunderstood doctrine. Case law is very sparse on it as far as from the old cases that we saw that people cite to. I think there should be new case law on commercial impracticability. I think that certain circumstances, and it's very fact specific, each company's contract, each situation, each set of events should be analyzed separately because that's the purpose of commercial impracticability, is to look at all the circumstances. It can't just be cost. It's got to be more than money. When we're talking about things doubling in price, freight, labor unavailable, things that the parties certainly never contemplated at the time they entered into their quote, their cost walk, their agreement, their fixed term purchase order for the life of the program. Talking about things that have changed so drastically that the circumstances are not at all what they once were. And ironically, if, for example, and that this is a great litmus test of whether something is commercially impracticable, if the supplier is so strained that they're going to go out of business if they can't get these price increases, I would submit that then the buyer ends up back in the marketplace. Buyer ends up back in the marketplace looking for a new seller, looking for a new supplier. And guess what? The terms of that contract are going to be as the circumstances exist now, with the super high raw material costs, freight costs, labor costs, and you're going to be paying the higher price as the buyer. So thinking about that in terms of what is commercially impracticable, even though the law isn't great on this point, the Uniform Commercial Code does have strong language on this point. And in my many years of doing these types of disputes, I don't think I've seen the supply chain as bad as it is right now. So if some of these circumstances that we're seeing aren't fitting for the doctrine of commercial impracticability, then I don't know why we still have it. And then I'll finish by talking about frustration of purpose, which relates to the buyer's contract being impeded due to an unforeseen event. Less discussion around this, but a lot in terms of services contracts as well as lease agreements. We're seeing a lot of discussion on that front. And Nick is going to walk through some of these cases and case trends that we're seeing. So what is fair and reasonable allocation under the UCC, and why is it so important? Fair and reasonable allocation, once the seller, the supplier, invokes the commercial impracticability defense, there is a built-in obligation that you apportion out what you have in some kind of a fair manner to your customers. But what is fair and reasonable is pretty broad. It's going to depend on many different circumstances, and many different courts will interpret it differently. What we recommend is to just have a plan and follow that plan. You can't show bias in your plan. So you can't have allocation based on customer price or profitability, allocation based on favored customers. And you're not supposed to have allocation based on customers that have agreed to pay more. Now, I'm sure some people are asking, well, how do we know? How do we know they're fairly allocating? Get a demand that you show your customer what your allocation plan is. There's supposed to be some transparency and some degree of trust, but the bottom line is there's really no way to know that the supplier was actually fairly allocating everything unless they'll show you all of their shipments and orders, which is unlikely given confidentiality and other issues. There's really no way to know it unless you proceed to a litigation. And that's why there's so very little case law on this, because most companies, by the time they're dealing with this, the stopping of performance, fight about prices, are you even fairly allocating to us? It becomes really a commercial negotiation at that point. Now, with that, I'm going to turn it over to Nick, who's going to have the unenviable task of doing several things. He's going to talk about some strategies for managing these requests for price adjustment, and we're going to look at it from both angles. He's then going to talk about some of the cases that we're seeing and just really show you that they're all over the map as far as the outcomes of some of these cases. And give the same dispute to 3 different judges. You're going to have one judge that grants your injunction, one judge that denies it, and the third will kick you out of his courtroom and tell you to figure it out.
Well, thank you, Vanessa. With that, why don't we, Vanessa's spoken a lot about all of the difficulties we're seeing in the supply chain. And as you might expect, and as many of you have probably seen, that is manifesting itself in requests for price increases, which are working their way all the way up the supply chain as different levels of the chain really try to deal with all of these increasing costs. So what are some strategies for dealing with these when you receive them, and keeping this in mind also when you are having to make them on the other end to your own buyers? These are this follows the playbook that you're going to have to see and respond to. First of all, as a buyer, especially if you're in a just-in-time industry such as the automotive industry, really the most important consideration usually is going to be to maintain continuity of supply to your end customer. Neither side wants to turn a dispute over a few $100,000 price increase into a situation where you now also have to apportion liability for $1 million or $2 million of shutdown costs because somebody, whether intentionally or not, took an action that resulted in shutting down a production line at GM, Ford, or another one of the major OEMs. So that's usually the first consideration. So when you receive a request from a supplier, what are the first things you want to look at? First of all, do I actually have an enforceable contract in place that requires the supplier to continue supply? In particular, you want to look at is there an enforceable quantity that the supplier is required to provide, and is there a duration for that contract? If I'm purchasing from a supplier on a spot buy basis and I don't have a binding obligation for future supply, then that really does put you in a tough situation, because if a supplier doesn't have an obligation to supply, they are entitled to impose additional conditions, whether that be a price increase or other commercial considerations, as a condition to accepting any future orders. Quantity and duration are two kind of special issues under the Uniform Commercial Code, which governs contracts with the sale of goods. Quantity is under the UCC. A written quantity is the only provision that the supplier must have in the agreement. Absent a written quantity, the contract is unenforceable beyond the quantity that's shown in writing. As far as duration, if you have a fixed duration, whether that is a contract that expires and renews at the end of every year, or whether that is even just a month-to-month agreement. If you have an actual expiration date, then that's something to be aware of. If there's no duration, if it's just an open-ended contract, then that is something that's considered a contract of indefinite duration. A contract of indefinite duration is terminable at will by either party on reasonable notice. Now, what constitutes reasonable notice may be subject to dispute, but if you're a buyer, it's not a situation you want to be in where the other side has at least some ability to, the seller at least has some ability to terminate the contract. Next, assuming there is an enforceable contract, does the contract actually provide grounds to support the request for the price increase? Some contracts, most contracts tend to be fixed price. Some may have provisions that allow for renegotiation of price in certain circumstances. That's always something to be aware of. Next, has the supplier made a claim of force majeure or commercial impracticability as a justification for its price increase? We are seeing lots of these from different suppliers working their way up the supply chain in various shapes and forms. As Vanessa mentioned, anytime you're talking about cost increases, not necessarily in the arena of force majeure, but if depending on the circumstances, there may be at least a potentially viable argument there for commercial impracticability that would support that type of request for a price increase. And next, if you're the buyer receiving this, be mindful of what requests you may have made to your own customer. We've seen different levels of the supply chain, the tier 2s, tier 3s in particular, are finding themselves really caught in the middle where they are telling their own suppliers no, they're not entitled to a price increase, but then turning around and having to make requests to their own customers. And in a situation where you wind up in litigation, all of those types of requests are going to be potentially discoverable. So having gotten through those initial considerations, what are your responses and remedies to a supplier? First of all, if suppliers threatening to stop shipment, you can consider requesting adequate assurance under the Uniform Commercial Code, adequate assurance written request demanding that the supplier confirm that it will comply with its obligations. And if the supplier doesn't provide that confirmation, then you at least have the ability to treat that as an immediate breach without actually waiting until the supplier misses a shipment. And that opens the door to seeking injunctive relief if necessary, which we'll talk about in a few minutes. Other options on the table are payment under protest. As we'll talk about in connection with the injunctions, a buyer, in order to get injunctive relief, a court order requiring that the supplier continue supply is going to have to demonstrate irreparable harm. If the buyer has the ability to pay under protest, that is, pay the price increase while reserving its rights and its objections that the increase is not properly owed, then in many cases that may be the way that a buyer has to go about resolving the situation. Pay the protest and reserve the ability to take a set off against the supplier later, or even file a lawsuit seeking recovery if the damages are significant enough. Depending on the nature of the supplier that's making the request, you can consider involving the customer. If the supplier has direct relationships with the customer, or if it's a directed supplier, then the customer may have some additional leverage. Although, as you might expect, most customers do not want to get involved in these lower level supply chain disputes, and unless really pushed to action, their initial default response is going to be, we expect you to manage your own supply chain. You can threaten to put suppliers on the no bid list. In this type of situation, perhaps not as powerful a threat as it may otherwise be if you're dealing with a situation in which supply is already limited. And then last, you can take legal action. You can actually file a lawsuit seeking injunctive relief or seeking damages. Which brings us to injunctions and equitable relief. At its essential nature, an injunction is a court order requiring that the supplier continue shipping and continue supply. Sometimes the court may set additional requirements, such as requiring the buyer to pay a price increase with a reservation of rights. In some cases, it may just be based on the existing contractual terms. In order to obtain an injunction, you have to show four basic elements. The first is a likelihood of success on the merits. You have to show a likelihood that the supplier is in fact obligated to continue supplying and is not entitled to the price increase they're requesting. Second, and this is the one that I mentioned a few minutes ago, you have to make a showing that absent the injunction, the buyer will suffer irreparable harm. Irreparable harm essentially means harm that cannot be remedied by an award of money damages later on in the case after a final judgment. Talk more about that in a moment. And the last two, balance of harms between the two parties and the public interest and public policy. Most commercial supply chain disputes turn on these on the first and second elements, likelihood of success and irreparable harm. But you will see in some cases where a judge wants to reach it, or feels like it should reach a particular outcome, they might put some additional weight on some of those third or fourth factors to reach a desired result. Likelihood of success on the merits, as I said, is there actually an enforceable contract that the supplier is obligated to continue supply? And what are the impact of the force majeure, commercial impracticability, force majeure and commercial impracticability arguments? As we'll see in a few minutes when we talk about the cases, courts have gone somewhat back and forth on those in the recent circumstances. Irreparable harm, harm that cannot be redressed by a final judgment of money damages. In most cases, courts do tend to bend that a little bit, particularly in a just-in-time situation where you're dealing with a major customer. The type and the level of damage that that you may incur if you shut down a major OEM. Courts usually recognize that is going to begin rising to the level of irreparable harm, just because they can be of such a high magnitude. And then there's also damage to reputation that courts will lean on to justify that finding as well. As I mentioned earlier, with respect to payment under protest, the irreparable harm rules can create something of a paradox, whereby if you're dealing with a price increase that the buyer has the ability to pay and thereby avoid a threatened shutdown, that may be a difficult situation to demonstrate the irreparable harm. If you're dealing with a price increase that $100,000, $200,000, the court may very well look at that and say, this isn't really irreparable harm. You have the ability to pay that under protest and then sue the supplier to recover damages. And in fact, there's an additional duty in some cases to mitigate that harm and pay that amount under protest if it's going to be lower than the amount of damages you otherwise would incur. However, what we have seen a lot more recently than in the past is suppliers refusing to accept that under protest language, demanding that it be removed. And as we will talk about in some of the cases, the courts have found that type of request does tend to move the needle much further into the irreparable harm territory. One variation on the pricing request and the type of difficulties we're seeing in supply chain is, what happens when you are dealing with a supplier that is not just asking for a price increase, but in fact is actually in financial difficulty and at risk of shutting its doors, going out of business, maybe in default of its loan covenants, and be subject to its lender repossessing its collateral, the means of production. Anytime you're in these types of situations, it really is much more dangerous, much more difficult as a buyer. And unless you have a readily available alternative source of supply, buyers' options are in many cases going to be very limited, and it's unlikely that the buyer is going to be able to get out of that situation without incurring significant costs, at risk of otherwise losing its supplier and potentially having a shutdown in production. The best thing you can do on the front end, really be aware of these situations. The earlier you're able to identify the problem and begin looking for alternative sources of supply or developing a strategy, you are going to be in a better situation. Some of the warning signs for a financially troubled supplier, if you're dealing with missed, late, or short shipments, consistent low quality, if you know the supplier has had long-term unprofitable operations, if you hear or get wind that the supplier is stretching its own payables or is not paying its vendors, or if they're turning around and they're making requests for you to shorten your payment terms or even to pay cash in advance for goods you're receiving. All of those are can be significant red flags that you may have a troubled supplier situation on your hands. When you do, first thing you want to look for is, do you have an exit strategy and an alternative source of supply? Are there other suppliers that can provide the same good? In some cases, you may even have the ability to in-source production depending on the product. To meet with the supplier and, if necessary, the supplier's lenders. If the supplier is in default under its loan covenants and operating under a forbearance agreement with this lender, that in many cases the lender may effectively be calling the shots and making the decisions, and it may be very difficult to obtain continued supply without involving the lender and potentially having to make some concessions to the lender to protect the lender's collateral, or at least in the lender's view, protect its collateral. It will be necessary to involve end customers, particularly if you're looking at insourcing or otherwise changing the source of supply. You're going to have to get approvals from the customer and expedite validation. Once you've taken stock of the situation, understand what your alternatives are, we have to decide, what is the best course of action? Is the supplier in fact viable long term, such that you can potentially stay and ride it out at some additional cost? Or is it a situation where this supplier really is in dire straits and is likely to close its doors? In which case, you really do want to look at getting out as quickly as possible. If you have the ability, at least the ability to stay, if the supplier is viable, or if you don't have viable alternatives, then you have to start doing those cost-benefit analysis. If you're forced to stay and you begin having to make concessions to the supplier, then you want to document those concessions. If it's just price increases, then potentially payment under protest. But if you're going beyond that, you may want a more detailed accommodation agreement and document what you are getting in return for those accommodations you're making. Whether that is the supplier affirming its obligation that it's going to produce once it receives these payments, or whether it is agreement on a defined exit plan in a period of time after which you will exit that supplier and be done with them. So with all these issues, let's take a look at some of the case law trends that we've seen recently. Particularly early in the pandemic and early this year, when we were facing true shortage situations, the courts really did look at the pandemic as qualifying under force majeure or commercial impracticability in most situations. Some suppliers perhaps viewed that a little bit too strongly. And they viewed force majeure or commercial impracticability essentially as a get out of jail free card, and overplayed their hand. Although courts have, as long as the predicate for force majeure and commercial impracticability, either that true inability to perform force majeure or the commercial impracticability necessary under the UCC are shown, courts really don't look too far down into the details of what is the supplier's motivation. It's really more of a factual inquiry: can you or can you not perform? Early on, buyers had relatively limited success in obtaining injunctive relief. Of course, recognizing that if there is no supply available, the court cannot order the supplier to provide what is not there. In particular, there was a case in Eastern District earlier this year dealing with the semiconductors that are so prevalent, JVIS USA versus NXP Semiconductors. The court looked at the situation, the shortage of and unavailability of the semiconductors, and said, this does appear to be a commercial impracticability situation. Therefore, the buyer did not have a likelihood of success on the merits, and the court denied a request for an injunction. Whether or not the pandemic was foreseeable to justify a claim for force majeure or commercial impracticability, in some cases may vary. The courts have looked directly at the contract to see what is covered by the contract and whether that was in fact foreseen by the parties. In two cases, Gap Inc. versus Pontgardia and UMNV versus Newberry, courts came to opposite decisions on this. In the first case, the court looked at the parties' contract and determined that the contract, in fact, sufficiently governed and considered the possibility that a restaurant owner may be prohibited from operating its establishment due to a government order, and determined that, in fact, the owner could not claim force majeure and commercial impracticability as a defense. In the second case, the court looked at the contract, found that it was not covered, and came to the exact opposite conclusion, finding that, in fact, the restaurateur was justified in claiming that its purpose had been frustrated and that it was unable to operate its operate its restaurant due to the government shutdown orders. As I mentioned earlier, we are seeing more and more sellers are starting to push back on payment under protest language. One case decided here very recently in Oakland County, this issue came to a head. The seller in court declined to agree that it would allow shipment under protest at the higher price, and based largely on that refusal, the court found that the irreparable harm requirement had been demonstrated and granted the request for preliminary injunction in favor of the buyer. More generally, we see the pendulum early on in the case. Courts are much more sympathetic to suppliers. Some of the more recent cases, the pendulum has started to swing back a little bit more in the direction of buyers, particularly where the seller is using the pandemic and supply chain issues more to justify or leverage price increases or other commercial concessions. I mentioned the HBPO case a moment ago, with the court granted the injunction based on, in part, on the refusal to ship under protest. Also, a recent decision in Isuzu North America Corporation, Progressive Metal Manufacturing Company. The court granted a temporary restraining order despite the seller's claims that it was dealing with labor shortages and other labor issues. And with that, I will turn it back over to Vanessa for a few minutes for some lessons learned.
Thank you, Nick. Okay, so you can see that these, do mute your line, that these cases are scattered. There's not as much consistency as you would expect. We are creating new case law on force majeure and commercial impracticability, case law that's from this century, so that's at least a progress forward. But there's going to be variation depending on the circumstances, the judge, the state you're in, et cetera. So what are some lessons learned? And I have a hard time predicting with too much certainty what the lessons are and what the key takeaways are from all of this. But here's just some observations. And taking a page out of the famous author Daniel Pink, he just recently gave a presentation that I thought was really enlightening. And he talked about not rules, because that's wrong. It's not one size fits all, and you can't say with certainty what's going to work for one company or one product with respect to supply chain. He wasn't talking about supply chain, but I'm going to steal his concept of lessons learned and not rules, but suggestions, and apply them to what we're seeing in the supply chain. Because suggestions are much more appropriate, and they're much more able for you to take back to your companies and tailor depending on the circumstances. But here's just 5 ideas that we have as to how risk can be mitigated going forward and improvements can be made. Not one size fits all, and certainly not appropriate across every single component that you source or supply. Okay, first, look at the entire supply chain and really engage in a mapping exercise where you look at where products came from and identify past issues with the supply of those components. It sounds really simple, but it's kind of failing to learn from historically what's happened. And I have this Winston Churchill quote: "Those that fail to learn from history are doomed to repeat it." And sometimes you will see that if you take a look at the last 5 years of your supply chain, you might find a problem location, you might find a problem supplier, and if you connect the dots, sometimes you can improve that way. So knowing the who, the what, the where, how far away the products are. Of course, the further away you're sourcing from, the more possibilities, the more entree points and connection points where you could have issues. I think we're seeing a lot of that with the current problems that we're experiencing. Some products are coming from thousands of miles away. I just read an article written in the Wall Street Journal about an average hot tub that consumers are buying has, if you add up all the travel miles across all the components, it's 800,000 miles. That's unbelievable. Labor force, looking at the labor force considerations. Have you had labor issues with certain suppliers? Have you yourself experienced labor issues in certain locations? Freight and logistics, critical right now. Looking at ways to streamline and improve freight and logistics. Third-party logistics companies, can you leverage them? Can they help you? Should you be looking to switch third-party logistics providers? Easier said than done, but these are long-term considerations. And then the availability of tracking technology and transparency. I know that a lot of industries are really good about this. A lot of companies are very forward about this, but knowing where your parts are and at what time. And then looking beyond just the first tier below, just the direct tier that's sourcing to you. And I mentioned this earlier, what if both of your suppliers or sub-suppliers have the same raw material supplier? Something happens at that plant or with that supplier. So it's important to look for both short and long-term precautions to potential supply chain issues. Okay, suggestion number 2, revisiting your terms and conditions and rewriting the force majeure provisions in those terms. First of all, having terms and conditions both on the buy and the sell side. And I know that before pandemic, force majeure was like a cut and paste. People would just cut and paste the same thing across all contracts, whether it was a purchase agreement for a major corporation or a toilet paper supply contract, and it would be the same no matter where you were sourcing from. And that is just not good. Before force majeure was cool, I've been talking about how important that provision is. It's a red flag provision. It's going to be a critical term if and when you need a timeout under the contract. I think there's competing considerations on force majeure provisions, depending on whether you're on the buy side or the sell side. Now, traditionally, force majeure was created to excuse performance. It's typically a seller-friendly defense to performance, a seller-friendly term in that it excuses the seller from supplying. However, very unique with respect to COVID, with buyers needing to reach out and declare force majeure as well, saying, we don't need you to ship parts. Please stop. Even though we sent that order, it's a firm order, do not send those parts. Our plant shut down. So you can see a lot of circumstances where it should be a mutual provision. And I think in most manufacturing settings, it is good to draft a mutual provision with limited exceptions. However, there's still going to be some tug of war with respect to what the buyer should want and what the seller should want. Buyers probably want that provision more narrow. Sellers want it broader. Buyers want labor out of there, make the seller responsible for their own labor force, might want to get rid of that catch-all language as the buyer, or any other circumstances beyond a party's reasonable control. Because that can be pretty broad and you can shoehorn a lot in there. But as the seller, you probably want that in there because you can't possibly predict all the horribles that could happen, as we've seen over the last 2 years. Very important that you have some time with which you're going to resume performance in this provision. Don't just leave it open-ended. It can't be a timeout forever, because the buyer is going to have to issue spot buys and cover and try and mitigate its damages. So the buyer's going to be back in the marketplace trying to reach a deal. It's going to want to try and get as good of a deal as possible for the term that it needs to cover. And it might want to actually just go back to the drawing board and get a new supplier if it's going to be too long of a time frame. So you do need that out clause, that escape hatch, as the buyer under a contract to say, we reserve the right to terminate. And I've had companies say, well, why can't I just use my termination for convenience provision? Well, because that probably comes with a whole bunch of obsolescence, and you don't want to be responsible for your supplier's obsolescence if they have told you they can't perform, but they've got parts on the water, raw materials, etc. Okay, suggestion number 3, consider allocating certain risks and fluctuations through the contract, whether it's amending it right now, trying to sit down and get the business teams aligned, or at the time of renegotiation. Maybe your contract's up at the end of this year, maybe it's not for a bit longer, but thinking about how we can allocate certain risks that probably we didn't think were risks before. We thought they were just certain things that we took for granted, and now we're seeing these are real fluctuating costs that do need to be discussed, negotiated, and considered. You can and should allocate risk under contracts. Look at existing long-term agreements, strategic suppliers, and say what is going to make this more fair going forward. Because there's been, I think, a great feeling of inequity and unfairness across a lot of contract relationships right now. Involve the contract managers, the owners of those business units in all aspects of where is the key red flag provisions and what do we wish the contract had been allowed us to do? Is it to sit down and is it to have an index in there, to have some actual index tied to certain prices? Or is it just at least to have a promise that we'll sit down in good faith if costs change by X% over X period of time? Look at stop ship issues, disputes, line downs, etc., and talk about how this can be more fairly allocated in the contract setting, because that's what everyone's going to keep turning to. And if it's not in there, then what's going to happen is, as we're seeing now, companies are going to say, well, you assume the risk, seller, manufacturer, because we didn't talk about this in the contract. Suggestion number 4, and this is a big one, but I'm going to throw it out there. Consider fundamental changes to the just-in-time lean manufacturing sole-sourced supplier model. I know that this is not possible across all components, all raw materials, all operations. Totally understand that. But at least try and avoid some of the problems with just-in-time. There are off-the-shelf components that you can consider setting up a dual source model for. There can be at least different locations that you get from. Don't just dual source and then source both from the same province somewhere in Southeast Asia. Think more strategically about 2 different locations, such that if one is impacted by some weather condition or some geopolitical issue, that you have your alternate source queued up, ready to go. What about warehousing or requiring suppliers to stockpile some quantity of goods? These are options. They might drive up your costs. Recognize that. I completely recognize that. But I think that some companies are looking out and saying, if we had just had a little bit of a different price, a little bit more built-in flexibility, even though that comes at a price, it would be worth it, given what we're dealing with now. And then number 5, considering fundamental changes to the length and distance of the supply chain. And this is, of course, a long-term goal. You can't just flip a switch. But companies are looking at strategies with respect to reshoring, nearshoring, and certainly regionalization. Again, long-term, easier said than done, but recognizing that you have more control when supplies and operations are closer. You have more options. For example, you have 3 mechanisms of getting a component from Mexico. It can be by truck, you can still do it by ocean freight, or you can do it by air. You don't have the truck option available for parts from Asia. It seems basic, but these are considerations that companies now are looking at and saying, this is really tying our hands to get product, and we don't know where it is or when it's coming. And then other companies are looking, and we see this with semiconductors and batteries, to acquire production facilities or enter into JVs to in-house certain opportunities. So those are my 5 suggestions. I know they're not one size fits all, but I do encourage you to just think at a high level about the pain points you've been feeling and some how you can lighten the load going forward by implementing some of those. Now I'm going to turn it back to Jenny to give you the CLE code.
Thank you, Vanessa. At this time, I will announce the CLE code. For those seeking CLE credit today, please type the following code into the meeting chat feature on your screen. The CLE code is VI2OA. I will repeat the code one final time. The CLE code is VI2OA. And now I will turn it over back to Nick to close out today's program. Nick, over to you.
Thank you, Jenny. And thank you, everybody, for attending. I apologize, we're running a little bit short on time here, but if anybody does have any questions, please feel free to reach out to either Vanessa or to I. More than happy to talk through any of the issues we've talked about. As Vanessa mentioned, we really are going to be dealing with some of these supply chain issues, I think, for at least some period into 2022 and maybe even beyond. So I think these are all issues that we're going to have to continue to manage. With that, thank you everybody for your time. I'll turn it back over briefly to Miriam and Jen Newman for a brief thank you from the ACC.
Thanks so much, Nick. Just on behalf of ACC Michigan, I just wanted to issue a huge thank you to Nick and Vanessa for presenting such an important and timely topic today, and to the entire team at Foley for being just so organized and thorough with preparing this webinar and putting it on today. We really appreciate the partnership, and we look forward to continuing it in the future. And thanks everyone for hopping on and participating today. Great turnout. Thank you all.